The state of Alabama takes child abuse cases very seriously, and understandably so. Prosecutors and judges usually are very harsh in this kind of case, and for somebody who's convicted, they're going to have pretty rough consequences. First, we need to talk about, well, what's child abuse under the law? So let me go ahead and read or tell you the basics. So under Alabama law, a person commits the crime of child abuse if they are what's called a responsible person, and that responsible person either tortures, willfully abuses, cruelly beats, or otherwise willfully maltreats a child under the age of 18 years. That's, in a nutshell, what the child abuse law is. What do they mean when they say a responsible person? Well, a responsible person simply is somebody who is basically the child is in their care, custody, and control. So that could be, of course, the natural parents, step parents, adoptive parents, anybody who's serving as a custodian of the child, whether permanently or temporarily. So it could be a babysitter or a day school. But somebody who is legally responsible for the child and does any one of those things, if they're convicted, would be guilty of the crime of child abuse. Child abuse has different ranges of punishment depending on whether it's a straight child abuse or the more serious level of aggravated child abuse. For a straight child abuse conviction, a person can go to prison for up to 10 years. For an aggravated child abuse, it can be up to 20. Aggravated usually means something along the lines of the child suffered some sort of serious physical injury, or the person has a previous conviction for the same thing, something that elevates the crime and makes it more serious. You need to understand that in child abuse cases, they're not uniform. What I'm trying to say here is that there is a range of less serious but still child abuse and more serious and not child abuse. And then, of course, there's some that are debatable as to whether or not it's child abuse. For example, most of us are familiar with where in the Bible it says, spare the rod and spoil the child. It's meant to get people to have loving discipline for a child, but it also recognizes that some kids, they don't respond to just harsh words. And so there are parents out there, and many, who will use some, whether it's a spanking or hitting a kid with a switch or even a belt, that do that. Well, does that mean that you're going to be arrested for child abuse? The answer is it really depends on the facts and circumstances and degree. Hitting a kid with a switch, depending on your politics, may be child abuse. It may be normal discipline. What a prosecutor is going to look at is, would a jury in evaluating this think, well, this is just reasonable parenting, or it's crossed the line? So obviously somebody can beat a child bloody with a stick or a belt or something like that, where most people are going to go, that's child abuse. Other times, a parent may say, go get me a switch, and whacks the kid on the butt, and most people would say, no, that was discipline. Maybe we don't all like physical discipline, but that wasn't a crime. Of course, at the other extreme are cases where just about everybody's going to look at it and go, oh yeah, that's child abuse. The classic where some parent burns cigarettes, or they do some sort of physical cutting on the children or something like that, where almost everybody's going to look at it and go, oh yeah, that's child abuse. So in these cases, if it is what I call a child abuse light case, a case where it's debatable as to whether or not the person either did something that amounts to a crime, or whether or not they even did the crime at all, then those cases are sometimes resolved relatively painlessly, in that the prosecutor might say, look, it's a questionable case. Will your person do a parenting class? And if they successfully complete it, I'll dismiss. If it's a more serious case, we may still, as defense lawyers, want a person to do classes in order to minimize the potential punishment. If it's a case where the person says, I didn't do it, it was whatever, it was the babysitter, it was the baby brother or the big brother or my cousin. Well, in those cases, of course, if there's a dispute as to what the facts are, the answer is a trial. So what happens if you or somebody you love is charged with this crime? First off, it's an awful charge to be charged with. It's listed as child torture, neglect, abuse, and things like that. Nobody wants to be charged with this. But the first thing that you should do, as almost in any crime, is you need to contact a lawyer as quickly as possible. And the advice that almost all criminal defense lawyers will give you is keep your mouth shut. You know, the police may want to talk to you, and usually do want to talk to you. It is very rare that somebody says something to the police that causes them to not get arrested. Usually people should keep their mouth shut until they have an opportunity to speak with the lawyer. The lawyer may advise them, oh, you do need to talk to the police, or the lawyer may say, you need to say nothing. But if you're in the hot seat, you really are best to speak with an attorney to figure out what is best for you and to protect yourself. If you, and I don't want anybody to be charged with this crime, but if you are charged with this crime and you're here in Madison County where I practice, feel free to give us a call. The phone number is below. I'm attorney Andy Siegel. And I hope you found this video to be educational and informative. Thank you for watching.